See, sir.
They have already lost the.
Sir, I have already instructed all those matters to be taken up first.
I paid.
Don't worry.
Taken up before writing.
Let us see, sir. We can't assure. If you argue, restrict your argument to 2 minutes, we will reach. It's up to you.
In answering for myself,
Or if you permit us, I will not allow you to argue more. I will be happy to discuss. If you argue for hours, I can't prevent you. Wait.
Item 1.
may please.
I'm getting a little background of this case also. Yes, I'll confine my argument within 15 minutes. Let's just I'm giving a little background of this case. The case is like this. Here the petitioners are working as a grammar sevaks. Initially they were working as a grammar sevak. It is a post derived under this that is NG Act. And their work to only to assist the Gram Panchayat and more especially in lordship, data entry operators, they are only they will provide data, upload the data lordship. The beneficiaries, it is also up to the state government. And lordship can come to Annex 1. Lordship can see page 37. Initially, after coming up with this special statute, if the state government came up with this notification, lordship, that is on 25/8/6 lordship. If lordship, I will read only 2 to 3 paragraphs lordship. Lordship, para 1 says lordship, all recurring expenses including remuneration and other ancillary expenses payable to such personnel will be within administrative cost of earmarked.
Where, which one?
Lordship, page 37, Annex 1, lordship.
Yes, I'm looking at it.
Lordship, just I'm reading para 1. That's number is 1, lordship. It starts from in connection with
Yes.
implementation of energy. Just I read out lordship,
Correct.
number 1.
So it will be charged. It will be charged as an administrative cost.
Lordship.
Then
Lordship, kindly come to 2. The engagements will be effected by the PRA bodies. Government will have no role or linkage to the engagement of this personnel deployment and other related matters.
correct.
Then lordship selection is there, then lordship kindly come to engagement of multiple assistant Gram Roja Sevaks lordship.
Correct.
Roman 1. One multi-purpose assistant Gram Roja Sevak will be engaged on contractual basis only in that Gram Panchayat which does not have a Gram Panchayat secretary. The Gram Panchayat will have a secretary will also perform the works of the Gram Sabha and will responsible for purpose of maintenance, accounts and database in the computer and to discharge the duties and resolution under the energy. Let's say to this. So lordship, this appointment, this in all over state there are around 6,000 Gram Panchayats lordship, and this all the posts lordship created as a contractual service under the Gram Panchayat and by the Gram Panchayat lordship to perform as a GRS and secretary of the Gram Panchayat. So then lordship kindly come to lordship, which is the MG Energy's guideline that starts from page 40. There also the central government come up with this guideline. Lordship giving the entire power to the Gram Panchayat. Lordship kindly come to the state. Lordship kindly come to page lordship 51. Lordship, I'm reading page 51. Lordship, the para starts from they are. Para 2, lordship, only last sentence. The staff provided to the Panchayat under MG Energies, lordship, under the MG Energies would work under the superintendents and the control of the Panchayat concerned, including decision powers. So all these 6,000 posts are under the Gram Panchayat and they are the employees of the Gram Panchayat lordship. That is my whole solution for lordship. Because as like a secretary, they have engaged as the post of secretary lordship. And subject time to time lordship, government has come up with rules lordship. And lordship kind in 2008, the state government come up with the rules lordship only to accommodate this Gram Panchayat secretaries to the post of Panchayat executive officer. And that's a one stroke lordship by giving age relaxation. Lordship.
Show us.
Lordship, page 53, Annex 3, page 53, lordship. Lordship, in exercise conferred by the provision.
No, it's the governor. Once is.
But lordship kindly state from the rules. Lordship kindly come to 8, clause 8, lordship. that is speaks of eligibility criteria and procedure for filling of vacancies, Lordship. In order to eligible appointment for the Gram Panchayat secretary must have passed a high school certificate examination or any examination equivalent thereto, or have passed the middle English school examination or other examination or equivalent standard and have rendered at least 15 years of continuous service of Gram Panchayat secretary. The committee shall meet at least once in a preferable in the month of January to prepare a list of Gram Panchayat secretaries as held by them suitable for promotion to the post of village level workers, taking into account the existing vacancies and anticipated vacancies of the year. For the purpose of consolidation promotion, the appointing authority shall prepare a list of Gram Panchayat secretaries in the district according to their date of substantial appointment to the post of Gram Panchayat secretary. Then Lordship 9 they have come up with rule 9, procedure of filling of vacancies, and now it is exhaustive, Lordship. They have already given appointment to the Panchayat, those are working as Panchayat secretaries. They have been absorbed, Lordship, post of PO, Lordship, Panchayat Executive Officer. Then, Lordship, our position is Gram Panchayat secretary.
Where they have been absorbed as a Panchayat executive officer.
That is VLW, Lordship. No, sorry, I'm exclusive. VLW service. That is village level worker. Lordship, I'll come to that PO, Lordship. Then, Lordship, kindly come to this guidelines. This is for the secretaries, those are working for continuous 15 years. They have been absorbed to post of VLW. Then, Lordship, kindly come to Annexure 4. Lordship, state come, Lordship, Annexure 5. In the 13, the state government come up with another, Lordship, that is rules, Lordship, that is amended rules. 61. Odisha village level workers recruitment and conditions of service amended rules no 13. Here, Lordship, first time our position appeared, Lordship, that is clause 2, Lordship, kindly see rule 2. In case of non-availability of eligible Gram Panchayat secretaries, the post remaining unfilled shall be filled up in the following manner. 70% of vacancies shall be filled up direct recruitment, Lordship, under rule 9. 30% of service vacancies shall be filled up by the selection from among the Gram Rozgar Sevaks. So, Lordship, for the first time, the state government accommodated us by giving 30% preference, Lordship, to be filled up. And this practice was going on till 2021, Lordship. And in almost, Lordship, maximum number of the same benefits have been extended to all our co-employees, Lordship. They have been given appointment. Now the present cause of action, our Lordship, by a this, Lordship, notification, that is Annexure 10. We are argued by Annexure 10. Page, Lordship, Lordship, page 93, Lordship.
Yes.
Lordship, here they come up this rule that is, Lordship, with Lordship name and style. That is the rules may be called Odisha Panchayat Executive Officer Service Method and Recruitment and Conditions Service 2021. Lordship, in the meantime, just I want to just something, Lordship, in little change is there, Lordship. In the meantime, Lordship, the Gram Panchayat Act amended. And in the place of secretaries of the Gram Panchayat, they were renamed the Executive Officer of the Gram Panchayat, Lordship. And which was challenged before this Honorable Court, the validity of this Section 152
has been upheld.
Lordship, in fact, Lordship, in that condition, Lordship, Lordship, can just I'm letting Lordship, in that condition, Lordship, remaining all other conditions, all the persons, those are approached this had approached this Honorable Court, challenging 122(3), giving power action to the officers of the state. The subsequent that were declared ultra virus, Lordship, and they have come up with another amended rule.
Subsection 3 was declared ultra virus.
122(3).
I understand.
Lordship, declared ultra virus, plus judgments are there. Lordship, declared ultra virus, receiving, Lordship, in view of the Article 243, Lordship, some court had, Lordship. This is self-governance system. The officers cannot interfere with the affairs of the Gram Panchayat. It amounts to, Lordship, against provisions of the Constitution. And Lordship, after they have amended, now they have created the post Panchayat Executive Officer. And while bringing such position, Lordship, they till 2004, since 2004, they have never come up with the present rules, Lordship, the post Panchayat Executive Officer. For the first time, after 20 years, Lordship, they have come up with the rules for the first time for appointing a Panchayat Executive Officer as per the statutory provision, Section 122. But here, Lordship, the same thing. Our grievance here, Lordship, because since 2013, you are periodically you are accommodating the all grammar sevak, those who have completed numbers of period service, Lordship, because our appointments in 2007, Lordship, because 2006 5 statute comes and since 2007 they started our giving us appointment. So, Lordship, after serving a more than 15 years, Lordship, they have by this rules they have taken away all our right, Lordship. And their Lordship, that was the subject matter of the application. Lordship, can you see page 94? Page 94, they have defined us in this rule. That is G, Lordship, to G. Gramya Sevak means persons who have engaged as such in the Gram Panchayat under the Mahatma Gandhi National Rural Employment Guarantee Act 2005. Then, Lordship, can you see page 97? 7.2, Lordship, that is. We are agreed by this clauses. The Gramrochal Sevaks engaged under Mahatma Gandhi, sorry, the Gramrochal Sevaks engaged under Mahatma Gandhi National Rural Employment Guarantee Scheme in general, who are less than 45 years of age and are otherwise eligible under the provisions of these rules, shall be allowed to participate in the test subject to production of certificate from the collector of the concerned district regarding their community age Gramrochal Sevak. Provided said Sevak who have adversely reported and have no continuity of service shall not be eligible to seek the recruitment examination conducted by the commission. Lordship, then by particular this clause, Lordship, clause is very arbitrary. Reason being, Lordship, they have fixed the upper age limit of 45. Lordship, kindly see our situation, Lordship, visualize our position. We have been worked since last 2007, Lordship.
No reason.
Lordship. So, Lordship, in the meantime, we have worked more than 15 to 20 years we worked, Lordship. And now they have fixed the upper age limit of 45 years. If you have crossed that age, Lordship, we will not be accommodated. Then second, Lordship, they are saying the continuity of service. Lordship, last occasion I had demonstrated before the coordinate bench, Lordship. Perhaps, Lordship, there is not, you Lordship will not find a single person in the state. Those who have a continuity of service, Lordship, by way of executing agreement. It is a Lordship continuous Lordship disruption by the state government. Every year they are coming up with the rules. They don't have any continuity of the service. Because we are working in the Gram Panchayat and Lordship, the parameter is the agreement is never continuous. But we are working since last so many years, Lordship. This agreement is very formal in nature and they are creating by way of different rules, different notifications. So their own notification disturbs the entire Lordship continuity of the all the Gramrochal Sevaks. Then Lordship, kindly see, they are saying, Lordship, we will appear in the examination with the fresh candidates, Lordship. So, Lordship, kindly see our position, Lordship. Those who have been having experience and working more than 5 to 20 years, we are getting two, Lordship, barrier in the getting this appointment. One is age limit, Lordship, with continuous service. Then, Lordship, with meritorious, compared with the meritorious students, so those are freshers, so those are coming, Lordship, to the Lordship. And we have lost the reservation also.
Yes.
Lordship, can you see the 856, the Gramrochal Sevaks have allowed 1% extra marks of the total marks. So, Lordship, even if they are getting 30%, Lordship, we can compete, Lordship, but we have Lordship passed matriculation in the year 2006, Lordship, much prior to the 2001, Lordship. So, Lordship, we can compete this freshers, Lordship. And these two embargo, Lordship, perhaps compelled us to approach this honorable court. And right, Lordship, can you say, in fact, Lordship has given entry model. This entry model, in fact, Lordship.
Yes.
In fact, Lordship, that entry model still is operating, Lordship. But kindly say that there is an entry model. 7 to 30 days shoot. Lordship, the second page is Lordship. There. And one more development is there, Lordship. In fact, Lordship, this match the hard in length, perhaps in 4 spells, Lordship. and then Advocate General was appearing this matter. And while considering our grievance, Lordship directed to the state government, because you have exploited them since last 15 to 20 years. And being a welfare state, please accommodate them. Unless Lordship, it is will compare to pass some order, because they have been exploited, they are working since last so many years. And the Lordship, considering Lordship's direction, they have come up with a rules, Lordship. They have come up with a rules, Lordship, and that is called post data entry operator. And it's accounted data entry operator, Lordship. Data entry operator. And by of this order, many, Lordship, dramas have been absorbed. If we succeed in this application, Lordship, only left to us to get the avail the benefits of Panchayat Executive Officer. But perhaps that starts from page 3, Lordship. This is the first. Lordship, page 4, that is number is 36, Lordship page. That is on 27/2/2024, questions Lordship's direction. Because Advocate made a statement here, we are coming up with the rules, Lordship, and they have come up with the rules. And in Lordship, kindly see clause 10. In rule 10, Lordship, they have given benefits to the Brahmana books. In particular, Lordship, to extend Lordship, kindly the provided Lordship provided that. Clause 10 provided that as one-time measure, by relaxing the provisions of this rule, those grammar sabaks who have completed 5 years of continuous service on the date of commencement of these rules shall be absorbed on regular basis against vacant post of account from that entry, subject to fulfillment of other conditions of service, relaxation of upper age limit, if required subsequent vacant post created in the cadre of accounted shall be filled up as per the provision prescribed in the rules. So, Lordship, these benefits has given number of Lordship grammar sabaks in the meantime. If at all we succeed in the application by relaxing these two clauses, Lordship, definitely we will get a better post, and definitely our dream will be, Lordship, if we will get a post under the Gram Panchayat, whereas day one we are working under the Gram Panchayat. We are thankful, Lordship, to court and Lordship, and then come up with the rule, Lordship. Lordship, and it would be possible only because of Lordship's interference, and because of Lordship's direction, they have come up with the rules. Lordship.
No, now you are expanding the scope of the writ. The
Yes.
writ is limited to the prayer
Yes.
that limited to the prayer that annexure can be quashed
Yes.
and set aside, declaring it's an illegal, arbitrary, and contrary to the existing rules of such. So far as 122, section 122 is concerned, there is no challenge on that.
Lordship, if
Now the question is, if there is no challenge on section 122, then in that event, if the post of a Panchayat executive officer is there in place as per the statute,
Lordship,
and this appointment has to be made by the state government,
Lordship,
in that event, if the state government frames any rules regulating the method of appointment,
Lordship.
then in that event, can you come forward and say that it is not so? This rules is absolutely bad and arbitrary.
Lordship, today perhaps Lordship, I have changed my argument, Lordship, because there are two sets of writ applications. This argument of the for the Gram Panchayat, Lordship. That Lordship, your Lordship, which I should that point, Lordship, for that point I am not putting that writ application. I will not challenge.
Now, only
Lordship,
thing
as
is,
per
only
the
thing
second
is,
set-
the only thing is that GRS
Lordship, that
peoples are concerned.
Lordship.
For them, there was a special rules which was prepared for their absorptions, for their continuance, for their security, everything was done. Now, that rule has been amended from time to time and superseded by another rules.
No, this is the complete new rules, Lordship. That other rule is still prevailing.
Still
That
prevail.
rule-
So if you are
2008 rules.
eight rules is being amended, in 2013,
Lordship,
is being further amended.
2000
There is 21.
Lordship.
There is no difficulty, sir. We have seen that. Now this is a separate channel. Question is that if you are given or entrusted to handle the account,
Yes.
your concern is the handling of the account. I understand.
No, Lordship, in fact.
More problem is the handling of the accounts.
Lordship, in fact, I can
I
explain.
understand, sir. Entire argument when you hover around the different clauses,
Lordship,
accountant come data entry operator. I understood that your problem is the handling of the account. This account has to be handled by the panchayat. It should not be given to any person who is not a part of the panchayat.
no, my argument.
Sir, you may not, but the problem is this.
Lordship,
If you are a GRS,
Lordship,
your security in a service is ensured.
Lordship. Now,
Whether a person will do it, you will definitely be assisting them, the panchayat executive officer, in maintaining the accounts.
Lordship,
A single man cannot handle the whole accounts. He need a fleet of the staff to handle this. But at least the dominance would remain with the panchayat executive officer.
that's true, Lordship.
So there is no difficulty. How can you elevate your status? The secretary is a different, panchayat executive officer is a different.
Lordship,
How can you impose upon that I should be treated as a panchayat executive officer? Under what category? Under what law? Show me one judgment that it can be done. I am happy. I am with you, provided you convince us on a proposition of law.
But saying, Lordship, perhaps different, Lordship. But I'm saying you extended the benefits since you are 13 to 21 to other co-employees, Lordship, other Gram Sevaks.
Sir, it is
You
only
get-
in respect of a panchayat executive officer, which is an independent post,
Lordship,
only to monitor, supervise, or keep the entire functioning of the panchayati, which is there. It's a democratic process. Elected bodies are there. There is no difficulty. Only thing is, because the government is providing the money, giving a grant, at least the government want there should be some accountability and the transparency.
Lordship,
So he has put the executive officer, panchayat executive officer. No difficulty. And that panchayat executive officer cannot take an independent decision. It will be under the complete dominance of the
Gram
panchayat, gram panchayat. So it is always there is a creation of a post. That does not mean that you have a lien over that creation of the post.
No. Lordship, only we are confined to 2, class 7-2. If 7-2 will be deleted, Lordship.
No,
then-
if somebody 45 years, when you
Yes.
say the barrier, there is a provision for relaxation there also. If the government feels they can relax any of the conditions. Now it is within the domain of the
This can
government.
comment,
Take it.
They have come up with a Lordship guideline. If they will amend it, Lordship, then we don't have any.
No,
case,
no,
Lordship.
guidelines
Because
is for a different source. Is a
Lordship.
different post which is created. It has got no nexus to the panchayat executive officer post.
Lordship.
It is absolutely an
Absolutely,
independent,
Lordship.
different post. So if you are absorbed there, fair enough, no difficulty.
But
You cannot say. Sometimes then you will come and say that I am entitled to be a sarpanch by virtue of the rule. How can they eat up? Can you? Is a creation of a new post. It does not impinge upon your service.
Lordship.
It does not hampers your service. But you can't have a vested right over a particular post.
No, only we are saying Article 14, Lordship.
This is not Article 14.
Lordship, can you see?
No, if they say that for this purpose, I am giving what is there. First thing is opening an avenue or making an expansion of the eligibility criteria. Article 14 and 16 says everybody should be given an opportunity to participate.
Yes.
Now they say that you, the peoples who are already working as GRS,
Yes.
we are giving you an opportunity that up to 45 years of age, if you are there, you can also come and participate. So this is really expanding the horizon, nothing more than that, not breezing or squeezing the horizon. Can't be. Is a more transparent, or I would say a more expanding aspect, not curtailing. So you are there. There is no difficulty.
By a subsequent rules, Lordship, we are getting some benefit, Lordship, that is
You
there.
are, sir.
Lordship, interpret the.
At least the job security, at least the service conditions security is already provided to you. They have reduced to 5 years.
Lordship, they have, that is also, I'm going to they are saying the continuous service that is also coming on the way, Lordship, these are also, Lordship.
They
have
have
not
already,
defined how
they
this
have
continues.
already relaxed. They have
The
relaxed.
fact remains, Lordship, now the matter, Lordship, some, because now the person, those who are agreed their numbers now, Lordship, reduced to very less, Lordship, because maybe.
No,
Yes,
what,
but sir,
if they take away any of the service conditions which was there at the time of your engagement, certain benefits which were there, if they take away that, we appreciate it. Yes, you have a grievance. But one which is absolutely distinct, different, the whole problem. How can you say that I have got a vested right over that particular post? I should be considered to that post.
because they have done this, Lordship. See, but 13, they are.
Means you wanted that everybody should be absorbed and be taken as the Panchayat executive officer. Is it in a service jurisprudence, sir? Is it?
But it is still open to them to, Lordship.
That is up to them. What they will do is a policy decision. The court cannot mandate. Mallikarjun judgment is staring at my face of the Supreme Court.
Compelling them, compels them.
You are aware of the Mallikarjun judgment.
But that's true, Lordship.
So
A small observation will compel them to do something, Lordship.
can we? That's why I'm reminding again, Mallikarjun judgment you read. There the Supreme Court has deprecated that the court cannot issue a mandamus upon the government to frame a rules, to do or whatever, amend the rules, cannot do that.
But
That is what the Supreme Court deprecated.
Yes, Lordship, there is no such order. But they did it, Lordship. Because Lordship.
No, that is up to them what to do, but the court cannot issue a direction, sir.
Lordship, let them, Lordship, come with a solution.
No, it's not scuff. Why should we? Let them, they have completed their affidavits, let them. Let us decide. Yes, what do you say? Do you have finished?
Lordship.
Both the writ petitions?
No, Lord.
Yes, then come.
Your Lordship, kindly see,
What is your writ petition, sir?
plus second read application.
Yes.
So my friend has already brought to your Lordship's notice different rules. And I would be simply, your Lordship, on the basis of that rule. My case, page 54, second case.
Yes.
Lords, at the basis of the rule, a list was prepared. Final gradation list was prepared.
When?
But this-
Where, which page?
Page 59. Starts.
Just a minute.
We come to page 40, Annex 4A. Plus, this is a letter
Yes,
by the Commissioner cum Secretary to Government
yes,
to all collectors. The
yes.
letter contains as like this. Government, after careful consideration, have decided to allow all the collectors to fill up the vacancies of VLW. After keeping vacant post of VLW reserved for Gram Panchayat secretary by way for direct recruitment.
So percent and 70%. Then
Lordship, other things are there. I am just bringing
Yeah.
to Lordship notice. By way of selection from Amuga.
yes, yes, according to 2008 rules as amended in 2012 and 13.
Thereafter, Lord, this is 13. Lord, according to 13, they have decided this issue. Lord, where selection from Amuga Gram to Gram Rojagar Seva, following the provision contained in Odisha village level.
Sir, I am a very fast reader than you. I have already read it.
Yes, no. Therefore,
I say it has to be done only which should be filled up by a direct recruitments. Those would continue, but except those which can be filled up with VLW. So you were protected. You are VLW. You are protected.
no, we are Gram Rojagar Sevaks initially appointed. Lord,
Correct.
kindly. a gradation list was prepared. That is the contention of the letter.
Oh, that is a vacancy of ELW. Anyhow, yes. Then you are a Gram Rojgar.
Yes, my lord.
Yes, then
Then, my lord, final.
page 49, procedure for selection of Gram Rojgar Sevaks for VLW.
Yes, my lord. Then your lordship can see the final gradation list. Annexure 5, page 54.
Yes.
Then this final gradation list was prepared.
Yes.
And after the final gradation list was prepared,
Yes.
Annexure 6, page 66, the persons whose name find place in the final gradation list were given appointment. And
As
this system
VLW.
they
So
were given promotion. Look, these Gram Rozgar Sevaks were given promotion. Look, suddenly thereafter, your lordship can you see, even this continued till the new amendment came into force. Look, this they didn't stop here. Look, even after the amendment rule came into force, I have enclosed the documents in my your lordship can you see. Subsequently, thereafter also, they have given appointment to various persons of different your lordship can you see annexure 70,
page.
page 139. They have also given these Gram Rozgar Sevaks to the promotional post. This is the annexure 70. Even Koraput district, Kendrapada district, Samakhunta, all the persons of those blocks, they have been given promotion to their respective POs. So suddenly we have not given a jerk there by virtue of this 21 amendment.
What is your, again, I am putting the same question to you.
Hello.
What is your vested right in the post of a public
Since we are
Panchayat Executive Officer?
I am just bringing to Lordship's notice Article 14 and arbitrariness. Lordship, if we are continuing and
You are continuing.
we are continuing.
Where is a disruption in your service?
Because they have now they have broken the system of that 37 and 30% reservation.
What is
By
that?
notes of that,
That is 30% reservation for what post?
the post of PO lords out of the Gram
Sir, this is another post. This we are concerned with the Panchayat Executive Officer, PEO, not PO.
Lords, this attempt by the state government to not to give employment to these people because for this
You are in employment, sir.
lords,
Where you are you out of employment? You are in employment. This another rule of 24 takes care of your services.
lords, reservation if they do not give, then we will not get because we are
What reservation?
We are
Why? This is a policy decision of the government.
policy.
Whether to take the existing employees into a zone of feeder cadre or do not. It is up to them.
Lord, that's true.
You wanted to be a feeder cadre,
Your lordships can
feeder post. From there, you will be
your
considered.
lordship can make
20%.
judicial review of the.
Can I again? I am reminding you of Mallikarjun judgment.
Lords, I am
To bring out that Mallikarjun judgment.
bringing the lordship's notice. Your Onwar Aliska 1952 year 75.
Sir, latter judgment I am talking about, Mallikarjun judgment of the Supreme Court.
Yes, lords.
Please read that.
Lords, I am
And look and read the language in which the judgment is couched.
Lords, I have also judgments, their lordships insisting upon that arbitrariness and violation of Article 14.
Sir, this is a one aspect of the matter. You are trying to convince the court to issue a mandamus upon the government to amend the rules to keep certain percentage of post earmarked for those people.
No, we have never said for amendment of the rule. Look,
Whatever. Then what amendments
No,
to
look.
keep some avenue for you to go.
Look, because
Is
this,
it? I am asking. Is it? Can I do it? I am now putting up.
for giving a direction to state or any
Can I?
cannot be done. No, that I know. But so far the reservation part is concerned, continuity part is concerned, that is not there. They have been violated. That is the rule.
Let us see that whether you have the avenues to go up, whether you are, there should be some at one point of time, there should be a stagnancy.
No, there is-
Nobody can say that there should
So kindly
not.
say, I have prepared, Lordship, kindly say, this evolution of this system has come at 1989.
Yes.
Thereafter,
Have you got the
Lords,
judgment?
Subsequently, he can ask for this.
Hmm. Remember the parent judgment and subsequent judgment follows that.
This
also 2020.
Yes, yes, I know.
We can explain follow.
Correct.
So just asking.
You'll find that Mallikarjun is the parent judgment.
initially, Lord, this was in the year 89. 89, this
Yeah,
system of
we have-
the Sevak was there.
Huh?
1990, Mallikarjun Rao versus State of AP. 1992 SCC 707.
1990, volume 2, SCC, page 707, read that Mallikarjun judgment.
That is extracted at the report of 2024 judgment. This 2024 judgment.
The language is very, oh yeah.
It is settled legal proposition that the court can neither legislate nor issue a direction to the legislature to enact in a particular manner. In Mallikarjun so and so, VK Sood so and so. This court has held that the writ court, in exercise of its power under Article 226, has no power, even indirectly, to require the executive to exercise its lawmaking power. The court observed that it is neither legal nor proper for the High Court to issue directions
Look at the language
or
which is used.
advisory sermons to the
Advisory
executive
sermons.
in respect of the sphere which is exclusively within the domain of the executive under the Constitution. The power under Article 309 of the Constitution to frame rules is the legislative power. This power under the Constitution has to be exercised in the president by the president or the governor of a state, as the case may be. The courts cannot usurp the functions assigned to the executive under the Constitution and cannot even indirectly require the executive to exercise its lawmaking power in any manner. The courts cannot assume to themselves as supervisory role over the rulemaking power of the executive under Article 309 of the
I
Constitution.
think that forecloses all your arguments.
No, my lord, sir. My whole submission what I beg to persuade your lordship is
And this is followed in 2024 judgment as well.
Yogendra Mohan Sengupta.
the present rule has no retrospective effect. It is always prospective. They say themselves from the date of publication. My lord, your lordship kindly see, I have got a judgment, AR 90 Supreme Court, page 405. That is Mattis, Y. Angari and others from state of Karnataka and others. They are also relevant paragraph 5. I'm sorry, I have only one copy.
Just keep it and give it to me also. No?
Para 5.
No, what it says, tell me.
They say, Lord Samuel, it is well settled rule of construction that every statute or statutory rule is prospective unless it is expressly or by
So
necessity.
this is too fundamental. It is the first principles of the legal jurisprudence.
So therefore, I humbly
So
persuade your
who
lordship,
disputes
Lord,
that every enactment is always presumed to operate prospectively unless intended by the legislators to operate retrospectively.
Lord, their language
This
has
is
just
too
bring it to
simple.
us.
And a fundamental principles one cannot deny.
Plus, therefore, this has no, Lord, so far this petition.
Your services are not touched. Rather, your services is allowed to continue. It has a separate rules. It has a separate things which should go. Now they have come up with the another post, which post is by a separate rules which they have prepared. You cannot
Lord,
see
can they-
that I would get the lien. I have a lien or I have a vested right to such post. You can't create.
Just one tender condition, if lordship will see it, sick is page 23, lordship will kindly turn. Annexure 1, page starts from page 22. It's a tender, lordship will see. Page 22 is the name of the work. At
Yes.
the top itself. Cleaning of overhead water tanks of residential and non-residential buildings.
Yes, I have seen.
Let's see, got the page 22, annexure 1.
Nalko Nagar Township and
Right.
CISF colony.
Cleaning of overhead water.
Yes, residential and non-residential building. And underground reservoir.
Then kindly turn to page
7.
71. Straight away, I'll take your lordship to the tender condition, page 71.
Give me.
Experience criteria. It's one of the essential terms of the tender condition. Is experience criteria. Page 72. Page 71. Experience criteria, technical. Pre-qualifying criteria, PQC.
Yes.
Page 71.
Yes.
Lordship will see the bidder should have experience.
Similar work.
Yes. Similar
7 years.
Bidder should have experience of having successfully completed similar.
And the
work.
last of the month previous to the one in which
Right.
the NITs are invited.
Right.
So,
Then there will lordship will find 3 alternatives. 3 similar work completed works, each having executed value not less than 8.68. This is 1. 2. In case it is 2, then value proportionately increases to 10.85. If it is 1, then 17.36. But he must demonstratively show and file documents that he has executed similar work to that of page 22 means
similar work has been defined.
defined manner. Just see below that, similar work, just at the bottom of this page.
Yeah.
A similar work means cleaning up overhead tank, underground reservoir by mechanical means.
True.
Cleaning of a similar work means cleaning up overhead tank, underground reservoir by mechanical means. Now, what is that? Must be in relation to page 22. We're drinking what? Drinking, page 30.
Eh?
Page 30. Kindly see. Your lordship will find the penal provision here.
What?
We are 5.2, page 30.
Yes, the
The
technical
technical
acceptability will be
Acceptability
strictly.
will be strictly as per matching of PQC with submitted work credential by the bidder.
What is this PQC?
PQC, that the pre-qualification criteria which I have just shown to my lords, page 71.
Okay.
Now, you must show document to have completed work, either 3 or 2 or 1 of similar nature matching the value here.
No, what is the full form of PQC?
Pre-qualification criteria.
That
here.
is what is
Page
it.
71 it's there.
Yes, yes.
Pre-qualification criteria.
Okay.
Now, Lord, I confine to this only to the record, and I contend that it's an essential term. That's no doubt
True.
about this.
Then,
In view of clause 5.2, page 30.
yes, yes.
Now, page 79, your lordship may kindly.
Page?
79.
Yes,
Para
special
2.2.
conditions. Special conditions.
Right, special condition. Para 2.2. Rather, para 2.1, 2.2, both your lordship may kindly see. The scope of work includes carrying out cleaning of all overhead tanks into Nalko Nagar Township, CISF colony at HON'BLE, 2 times maintaining a gap of 1 year between successive cleanings. 2.2, contractor has to ensure that drinking
Bacteria
water
free and
tanks are-
safe.
Beg pardon.
Bacteria free and is storing clean drinking water.
Yes, sir. Contractor has to ensure drinking water will remain total bacteria free and safe enough for storing clean drinking water after cleaning of the tank. So it is all about drinking water, underground and overhead. And experience to that effect is an essential term. Now your lordship must see what the bidder, the private opposite party has given towards his experience. Times. Page 234. If your lordship finds that it is not matching the criteria, then he doesn't satisfy the essential term and his bid should have been rejected. Kindly see note page 234. Annexure 5. Lordship may kindly see. This is the experience certificate he has given. This is admitted portion. There's no dispute about this. Page 234.
Yeah.
But the experience certificate is, kindly see, subject, operation maintenance of wastewater treatment plant, sewage pump house for the year 2022. That's it. Got it?
Yes.
Kindly see the experience. Operation, subject operation, just below that column. Maintenance of wastewater treatment plant.
No, I have underlined it. Yes, we have seen that.
Then Suarez Pump House, what I contend is, and that too value, if your Lordship will see, the value is defined in the pre-qualification criteria. Lordship will see the value, page 236. Kindly see serial number 23, last of this column,
Yes.
23. Mechanized cleaning of sedimented sludge. That's it, got it. Then value is 57,518.7.
Yes.
And as against the value which I have shown to my lords, page that value, page 71, but you may see.
No, there are three criteria.
Right.
One is if it is a 3, then this much, 2 this much, 1 this much.
So it can't come below that. 1, 2. It has to match the experience, whatever is provided in the tender condition. 3. If the bidder doesn't
No.
match this,
That is what you wanted to say, that it should be relatable to the similar work. Similar work means the cleaning of the overhead or the reservoir or relating to a drinking
drinking
water.
water.
If it is not, then in that event, those are not the conditions.
A red alert has
PQC.
been sounded across
Is that
16
what you
districts of Andhra Pradesh.
And
The cyclone
this
Montha,
Lord,
barrels
one
And
just
you
the-
say that even if
The
all
Indian
those
Meteorological
work which he
Department
has
has
shown
warned that the storm
in
is
serial
likely to
number
make
1 to
landfall between
23,
Machilipatnam
these are all
and
relatable to
Kalingapatnam
sludge,
near Kakinada
Sludge,
relatable
this
to
evening or
something
tonight.
else,
Where
not
Backing winds of
drinking
90
drinking
to
water.
100 kilometers
Not
per
I
hour,
understand.
gusting up to 110 kilometers per hour.
Lord, what they are trying to now
The
tell is,
cyclonic storm, currently moving northwestwards over the Bay
Lord,
of
para
Bengal,
4, page
has
2 of their
already
conclusion,
triggered
you see how
moderate
they have
to
tried
heavy
to
rainfall
customize.
across the north coastal districts.
Para?
Visakhapatnam,
Para 4, page 2 of the
Srikakulam,
conclusion.
and Anakapalli received up to 92 millimeters of rainfall on Monday, while
Counter
central and
affidavit.
south coastal
Filed
regions
by
experienced
OP
light
number
showers.
1.
Prasanjit
Chief Minister
Kusti.
Chandrababu
Lord,
Naidu
it
has
is by
convened a
yes,
high-level
Prasanjit
review
Kusti.
meeting, directing
But you may
officials
see
to
para
ensure zero casualties and
But then I'll
immediate
take you
relief for
to
affected
the
residents.
other part of the case.
He
But
said
before
Prime
that, I
Minister
must show
Narendra Modi
their counter
had personally inquired
that the
about the
contents
situation
of para 2
and
are
assured
denied.
all possible
There is
assistance
no
from the
violation of the
center.
terms and conditions
To
by the
minimize
presence
the
of the party.
impact, the government
OP
has
number
launched
2 was technically
large-scale
qualified.
evacuation
I
operations.
was
So yes, say 23 is
187 pregnant women with
mechanized cleaning
medical
of a
cabs
zero
and emergency
discharge
services,
dump pit.
while NDRF and
Is an
SDRF teams
underground
are on full alert.
reservoir, so
The
he has
administration
undertaken the
has
similar
deployed
work. So, but he does
3,211
not know,
generators,
does not say that
851
what should
earth
be the
movers, and
quantifications.
That is
757
one
power
two.
saws
Doesn't say
across
that it's a drinking
110
water.
mandals to handle power
Whatever.
outages,
Yeah.
clear fallen
Then
trees,
you also may
and
see
restore
during
damaged
technical evaluation
roads.
of offers by
The
the
Indian
designated
National
committee,
Center for Ocean
whenever
Information
some of the
Services
items of
has
BOQ of
issued a
any work
marine
submitted
alert,
as taken,
forecasting
credential for
high
particular
waves
vendor
of up to
satisfy the similar
4.7
work definition as
meters
defined in
and
the
a storm
NIT,
surge of
then the
about 1
same,
meter,
same work
which
order is
may
considered to be
inundate
satisfying
low-lying
similar
coastal
work
areas
criteria.
from
And total
Nellore to
executed value of the
Srikakulam.
said work is considered for evaluation
Authorities have
of
urged
qualifying the
residents to
value
remain
criteria.
No,
indoors
he talks
and follow
about
official
23 also,
advisories
but
as
he
Cyclone
has not
Montha
talked about the
nears landfall
quantum.
tonight, threatening to unleash
Now,
powerful
Lord,
winds
one just
and heavy
small
rainfall
suggestion before I
along Andhra
conclude.
Pradesh's coast.
They are relying upon a judgment because if your Lordship will see, your Lordship may kindly take that small list of dates. Wait, I will check. Lord, when notice was issued during pendency of the writ petition, Lordship may kindly see this date, take these dates. Lord, after notice was issued, we brought it to the notice that writ petition is pending. They issued a, despite pendency of the writ petition and knowing well about this, they have issued the work order. And it's a list pendants work order. That is why your Lordship on 30th of July 24 protected to the extent that
Final outcome.
subject to result of the request. Now today, my Lord, from the date of work order, it is 1.5 months has lapsed. 1 year has lapsed. I'm sorry, 1 year has lapsed. It has lapsed 1.5 years. Now what they are saying is, since they have executed the work for 1.5 years, they are claiming equity over the work, despite they do not satisfy the terms.
But because of the interim order, no equity.
No equity can be claimed. 1, 2. They are relying on NG projects. Sir. NG projects, Supreme Court judgment is there. Judgment of the Yes, they have given a judgment to claim equity. Para 23 for Lordship to kindly see that judgment. They're relying it in their favor. Para 23. Let me distinguish. Otherwise, okay, any other? Don't have a copy. Para 23, Lordship may kindly take. Correct. It's a infrastructural tender relating to infrastructure means construction of road work. And keeping that in view, this judgment was delivered at 23. In view of the above judgments of this court, the read court should refrain itself from imposing its decision over decision of the employer as to whether or not to accept the bid of a tenderer. The court doesn't have expertise to examine the terms and conditions of the present day economic activities of the state, and this limitation should be kept in view. Courts should be even more reluctant in interfering with contracts involving technical issues, as there is a requirement of necessary expertise to adjudicate upon such issue. Approach of the court should be not to find fault with the magnifying glass in its hands. Rather, the court should examine as to whether decision-making process is after complying with the procedure contemplated by the tender condition.
So they wanted to say that even if there is an infraction, there is anything, it is open to you to claim a damages, and the writ court should not interfere.
Only when. Let's see the contingency in the preconditions mentioned. Only when, but the approach of the court should not be to find out fault with magnifying glass in its hand.
No, I'm talking about the in between placetum G and H.
Right.
The sentence begins with if the court finds.
Yes, that's what I'm trying to deny.
No, that is what's. Please look at it.
Yes,
If the court finds that there is a total arbitrariness,
yes,
or that the tender has been granted in a
Right.
malafide manner, both the cases.
yes,
Let us go arbitrariness and malafide.
yes,
Still, the court should refrain from interfering
right.
in grant of the tender, but instead relegate the parties to seek damages for the wrongful
Now your
exclusion.
lordship is to look into whether ratio it's a ratio decision is statistics or it's an obiter. Number one. Number two.
What? It's a
Lord,
direct.
I'll take it, I'll take
Is
it.
Article 141.
Lord, I distinguish this judgment because Lord, if your lordship says that an essential term of a condition is violated, I'll take your lordship to the further field.
It has gone. Then
Those two
suppose
judgments have not been considered.
Suppose if the essential terms and conditions is violated, then it's an arbitrariness. It's absolutely a malafide on their part to do it. Still, the court has said that don't interfere. Go for a damages.
This
Relegate the
observation,
parties to claim that.
This observation, Lord, I'll just try to distinguish the judgment. Lord, Lakshmi, kindly take this one page note prepared by me. Why I am trying to distinguish this? Lord, Podar Steel and Vidarbha has not been taken into consideration, which mandatorily say in case of violation of essential
Are they a judgment of the larger CORAM, or they are the judgment of others?
These are the earlier judgments of the Honorable Supreme Court, which have not been taken into consideration.
Coordinate or co-equal strength.
Coordinate bench judgments have not been taken into consideration. And your lordship may say it's substantial or Lord,
Not substantial.
no, your lordship may say
Can't
per
be.
incurium. Your lordship may say per incurium. The reason being, earlier judgments have not been taken into consideration. Podar Steel and Vidarbha, these two judgments in loud and clear words have said that in case of violation of an essential term, the entire tender process has to be set aside because they are all voluntary. The tender conditions which are essential cannot be thrown to the dustbin by the authorities. In the process, in the garb of damages, they cannot throw away, they cannot hide their lacuna here in the tender process. Kindly similar those two judgments. I have just come to assist your lordship. I have got those two judgments. Judgment of the compilation. Kindly similar. Vidarbha, your lordship may see para 14 and 16, first judgment. Lordship may kindly straightway come to page 8 of my note, compilation.
Which one you are?
This is Lord, 2020 17 SEC 577.
Yes.
Lord, your lordship may straightway come to page 8 of my compilation, para 14 and para 15.
Para
Para 14.
14 and 15.
Right. Kindly. Doxy security BSN Joshi, they have been taken considered here. The law on the subject is well settled. Boxy security and personal services so and so. Law is settled that essential condition of a tender has to be strictly complied with. Other Steel Corporation so and so, this court has held. Requirement in a tender notice can be classified into two categories. Those which lay down the essential conditions, eligibility, and others which are merely ancillary or subsidiary, with the main object to be achieved by the condition. In the first case, the authority issuing tender may be required to enforce them rigidly. In the other cases, it must be open to the authority to deviate from and not to insist upon strict literal compliance with conditions in appropriate cases. Then para 15, BSN Joshi, let me kindly see. Similarly, in BSN Joshi so and so, Roman 1, if there are essential conditions, the same must be adhered to. 2. If there is no power of general relaxation, ordinarily the same shall not be exercised and the principle of strict compliance should be applied where it is possible for all parties to comply with all such conditions fully. 3. If, however, a deviation is made in relation to all the parties in regard to any of such conditions, ordinarily again a power of relaxation may be held to be existing. 4. The parties who have taken the benefit of such relaxation should not be ordinarily allowed to take a different stand in relation to compliance with another part of a tender.
No, that is what it says, that the judgments are to the galore that once there has been the conditions stipulated in the tender document, then the authorities have to strictly follow it.
Yeah.
Now there are two contingencies. One is
Essential and
then
non-essential.
essential, and another is a ancillary or
Correct.
incidental to thereto.
Right.
In those cases, so far as the second one is concerned, there can be a relaxation, there cannot be any difficulty. But if it is a straightforward and does not require anything, primary object is such,
Fulfill that criteria.
then in that event, it cannot be relaxed
Cannot be.
unless the power to relax
Is there in the tender
is there in
condition.
the tender condition.
But next, your Lordship would kindly see. Below this is a case, given by judgment of this Honorable Court, AF Enterprises, Lord para 11 and 23.
Para
11 to 23 starts from page 11 of my compilation. Page 16, your Lordship would straightway come. Page 16.
it is all the reiteration of the same judgment, sir.
Read at the same view, Miller,
Is the reiteration of the
same
same.
view. Then your Lordship will see Aparna Sahu, the division bench judgment of this Honorable Court, page 20. It is of the same view again. My Lord Justice Raman was also a party to this judgment, page 20. Your Lordship will get the paragraphs. Para 15, 16, and 17, page 26 of my compilation. Vidarbha is considered here, Afcons is considered here. Same, essential, not essential.
Tata Cellular is a
Yes,
both
sir.
operative judgment,
Considered
authoritative judgment.
Unless it is malafide, biased, and arbitrary in the decision making process. Then page 30, Sachin Agarwal. Of the division bench judgment of this Honorable Court. This says the same thing. It was a case, delayed submission of bank guarantee after the cut-off date. Cut-off time, rather. This Honorable Court said, no, it's not permissible.
No, relaxation, it cannot be extended.
Cannot be.
No, that is. That's
one
a different
interesting
context.
that Your Lordship will find that relevant portion I am citing, page 54. This Chetan Agarwal case. Sachin Agarwal, para 16, Vidarbha and Boxy security are considered here. Durgavati Devi. Then Your Lordship will
No,
think-
the only thing is that one has to find out what is the essential conditions and what is not the essential.
That's all.
If it is the essential conditions, then there cannot be any relaxation in absence of any power to relax.
How is this? The tender notice, tender consent itself. But again, interestingly, Your Lordship will find page 59 of my compilation. This is really interesting. That judgment with that NG projects has been reconsidered here, page 59. And the Honorable Supreme Court has said that High Court has wrongly considered NG projects. Here is a case, Lakshmi see. The same bench, the same Honorable bench of the Honorable Supreme Court, kindly see, my Lord, page 59. Here is a case of rejection of a tender, acceptance of a tender, violating the essential term. Referring to NG projects, High Court allowed that. Honorable Supreme Court said NG projects has been wrongly considered. Kindly see. But page 61, we have hard-handed counsel for the appellant. We find High Court has totally misread the judgment of this court. Respondent number 4 was declared eligible in a flagrant violation of principles of natural justice and all fairness in the process of determining eligibility of the tender. The bid of the respondent 4 was accepted when the time of
He
opening
says that he was disqualified at that point of time, so he cannot.
NG projects have been departed here.
It's true.
The same judgment on the same bill. In a latter judgment, say that NG project has been wrongly applied. So, so therefore, I say that doesn't hold the field in view of this latter distinguishing judgment passed by the honorable same bill. Now, your Lordship will see page 62, page 63, Devidatta Mahanti honorable Supreme Court's case. Lordship will find here, so it was a case of bangaring, solvency. On the basis of an invalid solvency, the bidder continued for about 3 years. Now, the judgment of this honorable court, I had the occasion to appear there also. The collector's order to cancel the lease on the basis of invalid solvency was set aside by this honorable court. Now, matter went to the honorable Supreme Court. Honorable Supreme Court set aside the judgment passed by this honorable court saying, once there is an illegality in the process, it has to be taken to a logical end. Cancellation of lease has to be there. After 3 years, kindly consider this judgment, not page 63 onwards. Collector's order of cancellation after 3 years he was operating this side was set aside, was upheld by the honorable Supreme Court. Equity was not considered. Equity part was not considered by the honorable Supreme Court. But one question may come from my lords, my lord. If there is a equity and law are pitted against each other, which one will prevail? Here,
Law.
law will prevail.
Obviously, there cannot be equity.
That cannot
Divorce
be
the
apart
law.
from law in case of it.
Divorce the law. Cannot be.
Para 29 is a very short paragraph. Para 29 is a very short paragraph. Para 29.
Last line.
Right. Last. I'm so grateful. Dora Lex and Lex. One thing just I'll show and conclude here. Lordship will see page 30. Page 30 of my deed. This condition of compliance satisfying similar nature of work is essential. Page 30, I'll just show that and conclude. Just at the cost of repetition, I'll show it. Page 30 again, Lord, I have shown this clause to my lords, my lords. Kindly see bid evaluation, technical acceptability. Clause 5.2.
Yes, it's strictly as per the matching of the. That is why you are. What do you think?
So great. I'm sorry. So great.
Yes. Yes.
Lordship may kindly have a glance, page 71. The qualification criteria which has been relied on by my learned senior. Then the third condition is that the requirement is one similar partially completed work with having executed value not less than 17.36 lakhs.
So where is that 17.36?
And the similar work has been defined as cleaning of overhead tank or underground reservoir by mechanical means.
Correct.
The work order which was submitted by the successful bidder starts at page 234. Page 234, the work order total value was for rupees 32,52,000. And so far as the similar work is concerned,
No, you come to 236 is really the breakup of that.
not so. 236, admittedly, only serial number 23 was the similar work. Because that was in respect of the underground reserve.
So if it is less than 16 or 18 lakhs, which you have just shown for one work, then do you think that it matches with the similar conditions?
Erasing, in fact, what we have done
Because had you take the whole of the amount
No,
relating to 23 items of work, then it exceeds.
then it exceeds.
But once you take a plea or no, the others 22 items are not a similar work, only 23 is a similar work. Then it does not go beyond that. It's only 57,000 rupees work. How can you match with these three conditions?
So,
3,
So
2,
for-
and 1.
when the complaint was also raised by the petitioner, we have considered that, and we have what we have said is
So
that for all
according to
tenders-
you, whatever you think is always right.
No, what my
I mean, there is a principle that the king can do no wrong.
what we have considered is the total value of the work order because this work order was also given by us, the similar work which has been relied on. So we were satisfied that he has experience of doing the similar work.
Sir, there are conditions. If you say that all these conditions can be relaxed, provided the authorities found that he has more expertise or the experience in doing the work, I appreciate it. No problem. You are an author of the document. You can definitely put any conditions which you can. But once you have not put any conditions, then what is the purpose of putting that PQC? There is no purpose.
But so far as even because what happened is in earlier tenders, this is the first time we had floated a separate tender for this work. Otherwise, in all previous works, this was only a part of the work tender. So that is why we have considered the total work order value because then it would have discriminated persons who had participated in our tender earlier and been awarded the work. So since we were not floating tender for this.
No,
work
if
only,
you decided that you will go to the persons who have done the earlier work, you can proceed on that basis. But once you have decided to float a tender, putting certain conditions, can you relax the conditions? Can you go beyond the conditions? Can you do whatever whimsically you think is required to be done?
No, see,
Then-
but only when my humble submission is that we have considered the total work order.
How? Then considered according to the terms and conditions of the tender. You can't ignore any terms and conditions of the tender. It's a mockery, if I say. Who compelled you to go for a tender? You may not have gone. Once you have gone, then you'll have to follow.
And in the meantime, in fact, more than the work was awarded for 3 years.
Then
18 months work
you have
has been-
deprived them
18 months work has been done.
who are the eligible persons, and you are given to a person who is apparently ineligible. According to your own stand, also it appears that he was ineligible
And from what he, in fact,
because you have restricted to item number 23. Item number 23, the quantification does not match with your condition.
is only item 23 was a similar work, right?
Correct. So that is what in your opposition you have taken.
No.
But that was only 57,000 rupees work. And why you have put a criteria of 18,000 or 18 lakhs or 16 lakhs? You have put a criteria.
Only one more
Oh.
submission also with regard to the judgments which were relied on by the learned senior. In the NG project judgment, the subsequent paragraph 24, Supreme Court has considered this aspect that when a substantial work has been done, at that stage the court should not interfere.
No, that is what then the subsequent judgment of the similar bench says that it has been misread and misconstrued.
The judgment in which the subsequent judgment,
So
then
any observations or a ratio has to be culled out from the facts which is involved in the particular case.
that is my humble submission because in NG project judgment, the facts were that substantial work was done. That is also the
Sir,
fact.
then in every cases it's too generalized. You are generalizing the situation where the approach is made immediately after the perceived illegality or a perversity, and time is consumed to decide the matter. In the meantime, that work is executed. So it has created an inviolable right into a person, and then he will continue. Do you think that this is the proposition of law?
This counter, he is not coming forward to say no
My only submission is that in the NG project judgment, the substantial work was done, which is not the case in respect of the other judgment. Even the other judgment, subsequent judgment, which has considered the applicability of NG projects, there also it has
Let
not
us see
considered
if
that.
there are earlier judgments which runs counter to this. Will you think that the NG judgments will have any binding precedence?
Earlier judgments are in respect of the tender condition. But so far as this aspect is concerned,
This
when
is
the
this is what is there. So the NG says even if there is a violation of the tender conditions, let us see to the extent of the arbitrariness, to the extent of malafide. Yet you cannot. But other judgment says if there is an arbitrariness, if there is a malafide, how can a one be a beneficiary of the malafide or arbitrary action? That means you are permitting a person to reap the benefits from his wrong. Can't. Yes. One has to just find out these judgments of this Bakshi and all, everything which is relied upon by the Supreme Court. This Uddar Steel as well. The Bakshi security, whether they are, what is the composition of the bench? Composition of the bench. Three or two?
I'll just begin this now.
Just place it to me for orders in the third week.
Great.
English.
No, in the second week.
Item number 3.
Let the matter be in the second week at the date be for orders. Under heading for orders.
Notice will go up, Chris.
Next, the notice issuance 24 for 2024. The answer notice returned to opposite fund number 1. The address is in left.
So-
Granted to the forest address.
Have you found out the correct address?
Yes, one of the.
Yes. 2 and 3.
1 and 2.
What has returned? 1 and 2.
1 and 2.
1 and 2.
Opposite party.
You are not appearing.
No.
Seen the office note indicating that the postal article is sent
Yes, compliance has been done in the Camelot. We had also sent the speaking order to the petitioner. Perhaps he has not been posted with proper facts. I'm drawing attention of the honorable court that we have already complied with. And I am serving a copy also to my learned friend for his perusal. That's it. We have disposed of this claim. Or claim.
Directed that they're to regularize the services.
No, consider
No,
the case.
consider,
Consider the case.
consider the case.
That the against the order of the tribunal, my lord.
Yes, the court. I have to rise 10 minutes before because of my some personal. Yes. I could not.
With
Yes.
some diffidence, I'm praying for an indulgence from my lords.
Yes.
Item 48, the other side is here. Because of urgency, my lord, this is the empty tax matter, but we are not concerned with the main matter today. There are two interim applications which were listed for today. It was the order on 6th October, the matter was taken up during the vacation, the direction was given for affidavit. My learned friends for the state have filed the objection today itself. So although there's nothing much, it's an amendment application. I have no difficulty dealing with the objection, but it will not be before my lords because they've filed it today. So I was requesting your lordships because it will not reach item 48. Any day, this will only take 5 minutes. At least the amendment application can be disposed of.
Amendment, why there are?
Not amendment, your lordship.
Whatever,
my-
then I'll argue with your lordship.
No, your application's prayer. The prayer in the IE is that to detect it from the
That's the
branch.
second application.
Your
I'm not
lordship.
on that. I'm on the amendment. There are two.
Suppose the amendment, I have no objection and
Lordship,
I have not
allow
filed any
amendment today,
objection.
Madam.
Let it be, your lordship. In both the applications, I am supposed to.
Whatever the amendment application, what amendment you want?
An additional legal ground is coming in. That's certain additional duties we are
That you can also always take. If it is a legal ground, no amendment is required.
But anyway, it's a challenge.
Is a benefit for the fraternity, then it's all right.
Fraternity also. Well, that is a IA number 7965.
It's an amendment. I dictate.
And the other matter is detagging that your lordship may consider later on. But I'm praying for.
It cannot be.
Very well. Lordship consider that later on.
Saying that you take it on the other day amendment.
But your lord.
You know for the benefit.
Yes.
So
There is some. My lord, the substantive prayer I'm asking is the lordship kindly fixes some day for this matter. This has been pending from 2017.
I came here in 2025. So let me try. Can it be done on 20th?
20th November. And it's also my duty to point out, I'm only pointing it out, that my lord was appearing for the department in this matter when it was moved.
Who?
Justice Raman.
Oh,
Yes, on the 27th March 2012. Of course, 13 years later, one cannot remember.
That has been disposed of. Initially,
It was revived. It was revived by the Supreme Court, the same writ.
That has
But
been
that is
revived.
for my lord. Don't misunderstand. He is entitled.
Original.
Yes.
Only there is a there
That
is
went to the
substantial
Supreme Court. Then it was sustained. The High Court order was
I
sustained.
think
And then it was revived by the Supreme Court, saying you revived the writ.
I think this was the first party when they offered 25%.
That's your lordship. Your lordship.
I just
So I should not be.
So I should not touch this file.
That is up to your lordship. We have no difference. I'm pointing it out.
it is a subsequent demand.
when you appeared in this matter.
Yes.
No,
So what
initially my lord was
No,
appearing.
if
That
it
has
is
been
not
disposed
pointed out,
Sir,
it's
if
something different.
he
It has
appeared
come
in
to-
this matter,
Yes.
then he should not.
Maybe
So it's my
come
duty
back
to
from-
point out. Well, I am very comfortable with this bench also.
In the state council, he appears in many files of the state. That does not mean if he shifted his position from that side of the room to this side of the room, he will not take
In
up
fact,
any state matter. No, that is not correct.
The order of the last day.
Anyhow, then
that is the-
amendment also should not be touched. So we are just recording since one of us record the name of Justice Raman is not inclined to take up this matter on his personal ground.
Amendment order, Amendment, your lordship, is not proper to pass.
No, no. For him, no.
Item number 45, the backup says, I have taken consent from the other side also agreed. May it go to any other date will not improve.
Let it be called, let us see. Today, all the hearing matters are there. Two have been already done. Let us see.
Item 5.
My lords, in item number 2, my lords had inquired about the bench composition. I'm forwarding a chart and the short submission.
Give.
May I please?
Yes, 5.
Item 5.
And please, the matters this review application has been filed against the order passed by this honorable board in the writ of it, but from the noting, it shows that notices have not been served, but in the list names are appearing. This is it may.
Who are you?
1, 2, 3, 4.
I mean the writ petitioner or opposite party?
Opposite party.
You are the opposite party.
Yes, you see.
How the review lies?
The opposite against the opposite party number
Sir,
4.
madam, the appeal was dismissed.
Appeal was
if you are-
if this review petition.
I just asked you whether you are the opposite party or the appellant.
Yes.
So you are the appellant. You are the appellant. Now, what is the ground of review?
Yes. May I take your lordship?
Yes.
First paragraph 2, your lordship may see.
Yes.
It is an error of the court.
What?
This of paragraph 2 of
Yes.
the review application that the appellant has filed the aforesaid writ appeal challenging the order passed by the honorable.
Where is the paragraph 2 of the which order you are assailing?
Yes.
Want to review 30th of April?
Yes.
Please, paragraph 2 does not say about it.
No, I am coming, madam. Paragraph 2 of my review application. First,
Oh.
the review application.
First, you show me from the judgment that what is the error.
Yes, madam. Page 11, your lordship may see that.
Please, I am looking at the order. Please tell me where is the error. What error?
Yes, madam. That paragraph 4.
Four.
We venture to devolve into the record in order to satisfy our concerns on the submission of advance transfer. Order number 6, as your lordship got it.
Correct.
Order number 6.
Yes.
That is with inverted comma ends. That is on the request made by the learned counsel appearing for the parties. That the order has been passed on the ground that as if I have challenged this order, but that is not the fact. I am taking your lordships to page 22, 23. Read appeal the order I have challenged in my this paragraph 2 I have mentioned. I challenged the order passed in the read appeal in IA number 4189 of
Can an appeal
2025.
lie against an order passed in an IA before the same bench? You are challenging an order passed in an IA where IA filed in connection with the writ appeal.
In the read petition in the IA,
Correct.
the order was.
What was the order? Where is the
Yes, sir.
where is the main writ appeal?
Page 22, 23, my lord.
Where is the writ appeal?
Yes, I have annexed. That is
You have annexed.
whole read appeal I have annexed. No, read appeal I have not annexed. Read
That is
appeal,
what
it has
show me the writ appeal.
The review application.
Please.
Step one.
Madam, let us.
Page 22, 23.
Just down.
What has happened?
Yes,
The
1 minute, madam.
Left out by this honorable court. This is this order is.
Where? If there is.
That is IA number 4189 of 2025. Part in the interim, the opposite party number 4 shall not be allowed to participate in the process of election.
28/3/2025 is the order which is challenged. Correct. And what we have quoted.
At the time of issuing notices, that order I so to your
28/3,
notice, and after that
2025.
being satisfied, notice was sent.
What is the difficulty? No? What is the difficulty? Hmm?
Annexus 7.
No, annexus
Annexus 7 is challenged.
28.3.
So this one.
20.
This order is
Last
quoted.
part has not been mentioned.
This quoted.
That first part,
So where is the order?
what has happened, your lordship has
Which
quoted the
order- which order,
last
madam?
part of the order.
Have patience. Which order you challenged in the rate appeal?
It is?
Appeal.
Yes. This
Which
only order passed by this by the Honorable Single Judge in I number 4189 of 2025. That order reads as heard in the interim opposite party number 4 shall not be allowed to participate in the process of election in respect of Kotak Bar Association to be held on 29 March 2025.
So
This
your
order-
grievance is that the full text of the order was not quoted.
Yes, that is the
Let it be quoted and the rest of the order will remain. No difficulty.
if that will, because on the pretext that that order has been left out by this court, so
I am
I-
asking,
I-
madam, I am asking, suppose a court has quoted an order. The entire text of the order was not quoted. Does it invite a error apparent on the face of the record?
certainly,
Certainly.
Your
So
Lordship-
we are saying that we are substituting that it would be read as the full text of the order in paragraph 4. Remaining order be there.
that order was passed. May I read that? Only on the basis that that second part is not there as if that order has not been passed without taking into consideration that second part, that which was order was challenged, that has not been taken into consideration and this court has reached to a conclusion. I am not an aggrieved party. My candidature has been rejected by
Which is
disallowing me to take part in the process of the election just before 16 hours. And only basing on that, without taking into consideration that the order, actually I have challenged. I have not challenged this order. I have challenged only that order passed in.
paragraph 7 is
So
also.
may I read it so that it will be clear? Your lordship will also find
Madam,
that
madam, at paragraph 4, we have quoted the order
Yes.
28/3/2025,
yes,
right? You come to prayer in your writ appeal.
No, she wanted. If you come to
I have challenged the order passed in the I. Because I was only agreed by that order. Writ is pending. And at the time of hearing of the appeal also, your honor was pleased to say that yes, that writ will be listed and till today for your this court's information that not yet. It is a backdoor business by depriving the right of an advocate who has rightly filled up for nomination and process of election has started just 15 hours before. It has been, and especially when the Bar Council and the election officer have come forward, filed their counter affidavits supporting the case of the opposite party number 4. Who else can cancel my candidature? Only the State Bar Council. And they have said that the president who is not, who has no locus standi to file the case, being a president, he has filed the case without knowing the law. Because of the Court of Bar Association
only the secretary or the joint secretary can file a case. The case has been filed by the president, and so many defects are there that has been pointed out by the State Bar Council, and accordingly, as per the request of the Court of Bar Association, they have rightly rejected. They have passed some orders, resolutions that has been not taken into consideration and suppressed by this Court of Bar Association.
File your affidavit.
Milord.
They did not.
File your affidavit to the review application.
May I submit, Milord, one thing? The order passed in the writ appeal was ex parte order. No notice was served on us on the writ appeal. Milord, here the interim order has already been implemented.
I understand.
There is nothing remains. And the writ is pending.
I understand. Now once she has come and then say, file your affidavit.
I'll file your affidavit.
24-3, the counter affidavit has been
Milord,
filed.
she admitted in the
4-3, before the order was passed on 28.
Madam, you are a legal expert. When a review application is filed, it is an independent application. The other side has a right to be heard on a review. We are not going, I am not going to decide the matter. So far as a writ appeal is concerned, we will definitely consider whether there is an error apparent on the face of the record. He has a right to defend that there is no error. How can you deny that right, which is a valuable right? Can you deny?
When the
Milord, wrong submissions were made.
That is what you perceive. That is what you perceive, that there is an error. There is an error. Correct. The court may not accept that this is an error apparent on the face of the record. Then what for the judges are here? To decide. You may say one thing, he will say another thing. The judge has to decide who is correct.
objection
So
on that.
that is what I'm saying. Let them give a objection.
That is the right
Milord,
of candidates.
it's a wrong submissions are being made, Milord.
Unnecessarily file your affidavit.
I'll file it.
Yes, the review is admitted.
Months they are
The-
preparing.
Review is
2-7
admitted.
listed.
The application for review or the review is admitted. बंद करो.
The publisher, books of publisher, my lord. And it has glanced under case number 4, paragraph 4, my lord. It is the also submitted, the offer for the makes it clear for 23 for supplied books in pursuant to the notice issued by the OSE Park, notice number EOI, that the expression of interest number 9690. That is 178233. Thereafter, the object party to state project director had issued to declare the list of name of the disqualified publisher of the final serial 23-24 my lord. How the name of the petitioner is not found place. That will presume that the petitioner was selected. The farm was not disqualified. Therefore, my lord, for a the petitioner neither received any supply order nor received a communication regarding the decision of the selection committee from of the party 2 months. The OSEPA website did not show the final selected list approved by the selection committee as per the official website of the EOI. Refer to the general instruction and terms and conditions. That condition, my lord, as EOI section 1I, that as quoted below, the final selected list approved by the committee shall be published in the OSEPA website for information of the participating publisher. But they did not update their list, final list, not intimated the petitioner regarding the status of the harm matter. The petitioner visited physically several times to the OP2 and they are advised, they are waiting for the website and they filed a representation to inform the status of the farm. That is pending. They not answer the representation letter. In the meantime, they have filed the counter. The counter, they reply particular paragraph 6 and 8, that is not required. The answer is not required. It presumes that they have not uploaded in the website the final list of the qualified farm.
Yes,
The matter has now become academic.
I have gone through that petition now. I have. The quoted portion I have said. He subsequently participated in another tender in November 2024, awarded a contract. He supplied the books.
That is a past.
No, subsequent thereto. In the month of November 2024, his 149 persons were selected for supply. Everybody, the order were placed, orders were there. He did not come. 148 person came. Agreement was executed within 10 days. Everything was done. And he did not. And he never approached. Simply making an email did not come forward.
Was thereafter has depended.
In the month of June.
Whereas completed in March.
Supply within 60 days from January.
Yes. Nothing remains for adjustment.
This is complete, my lord, administrative
And he has not.
The order was placed on you. If you do not come forward and execute the order, you cannot take an advantage. They have not disqualified you. They did not say that you are not there. Rather, the order was placed upon you. You did not come for an agreement and did not execute, so you can't say. Sorry, can't.
Not communicated the final list.
What are you talking? Not necessary, sir. Order was placed to you. Final list what? 149 peoples.
The order not submitted to me.
Yes, they have given you on an email.
No, my lord.
You are using that email and they have given.
My lord, you have given an affidavit.
Yes, affidavit is there.
You have given
Email is given to you.
B by 2 is. At least when I filed a representation, at least they give answer.
No, definitely not, because the representation was beyond the period of time. They say that you have not come up. Thereafter say that though the representations were filed in the email, yet we requested you to come and meet. You did not care to go.
I am searching my email, not send notice.
No, it must be in the spam. Sometimes may not be in a main inbox. Sometimes it goes.
13/6/2024, my lord.
Sir, it may not always be in the inbox. Sometimes it goes in a different box. You did not check.
And check the website, my lord, also.
Sorry, we don't know. We can't. Yes, the incident writ petition
Just to give a brief background to your lordships, if your lordships permit me, this is a tender matter, my lord, wherein my candidature has been rejected on the ground that I do not fulfill the working capital requirement as provided under clause 21B of the tender document. My lord, the tender was invited for the purpose of the removal of overburden and subsequent extraction of coal and its transportation. My lord, if your lordships may see the tender document, my lord, annexure 2, page 23, I'll very quickly show your lordship the dispute, and I'll show from their own document that their understanding is perverse. Kindly, my lord, take annexure 2, page 23, my lord.
Yes.
Yes. In this, my lord, at the bottom, if your lordships may see the work value which is given. My lord, first at the bottom column is estimated cost of work. Have your lordships got that, my lord? This is, my lord, without GST, 48 crore 60 lakhs and odd, my lord.
Yes.
Then, my lord, kindly see the next page, page 24. GST on the estimated cost of work, that is 874 crores and odd. And then, my lord, total estimated cost of the work is 5,035 crores. 5,735 crores, my lord.
Yes.
Now, my lord, and the period of contract is, my lord, 1825 days, that is 5 years.
Yes.
Now, my lord, may kindly take the eligibility criteria is at page 28, my lord.
Yes.
My lord, 2.1.a work experience. My lord, I am not troubling your lordship reading this clause in entirety because there is no dispute on this clause. I have the work experience. I have not been rejected on this ground.
Yes.
But only in this clause, my lord, I just want to show to your lordship there's a term annualized value which is defined in this clause itself, my lord, at the center of the page. Annualized value, if your lordships can see that, my lord.
Yes.
Annualized value of the work shall be calculated as, my lord, may kindly mark this estimated value divided by period of completion in days into 365. So, my lord, the annualized value of the work, if I put it, my lord, is, if your lordships may turn back to page 23 for a moment again, my lord.
8,000 something divided by 1825.
Yes.
To 365.
So that is divided by 5, my lord. It would be divided by 5 in substance. 5 because the work.
In days, it talks about in days. So it has divided by 1825.
Yes, 1825 into 365. So in effect, it will be 5 years, my lord, divided by 5.
Yes.
So now, my lord, that is not in dispute. What is dispute is what would be the estimated value. If your lordships may come back to page 23, my lord, for a moment, which I just showed to your lordships. There are 3 figures mentioned here, my lord, at page 23.
Yes, as one is 4,860 crore.
That is without GST.
Without GST, estimated GST is 874 crores.
And then
total estimated cost is this is the plus is 57 with GST.
Correct, my lord. Now, my lord, if your lordships may just see the writ petition pleading, because and the stand which they have taken, my lord, if your lordships may just take paragraph 14, 15 and 16 of the writ petition.
Yes.
That from bare perusal of the term annualized value as defined in NIT, it would be evident that annualized value is to be arrived at after dividing estimated value of work by the period of days provided for completion of work multiplied by 365 days. Estimated value of work under the NIT is given as 4860 crores and odd crores, and thus annualized value of contract in the present case would be 972 crores. That in order to participate in the contract, a bidder was required to have working capital of 20% of annualized value of contract as per clause 2.1.b of the NIT, and thus bidder should have at least 20% of the amount of rupees 972 crores, that is working capital of 194 crores. That petitioner had submitted requisite certificate as per annexure 12 showing availability of its working capital of an amount of 195.11 crores, and thus petitioner was having adequate working capital in terms of the NIT for being eligible to participate in the aforesaid NIT. Now, my lord, what they do now is, if your lordships may just see the clause of working capital which is quoted, my lord, is at page 29.
Yes.
Well, it says working capital, evidence of possessing adequate working capital, at least 20%. Page 29, my lord. I beg your lordship's pardon. my lord.
29, where working capital. Yes, B.
Yes, B.
Evidence of possessing adequate working capital.
At least
20%.
20% of annualized value or estimated value, whichever is less of this work, inclusive of excess of lines of credit and availability of other financial resources to meet the requirement. There's no dispute on this. Only thing is 20% of annualized value or estimated value. Now, 20% of annualized value
is 194 crores, where you have shown 195 crores.
Yes. Now, what they are doing is, what the respondent did is, kindly come to my paragraph reading, paragraph in the writ petition is at paragraphs 22 and 23. And then I will show the perversity on the face of it when I show that own document what they have done. Paragraph 22 and 23, if your lordships may see, it's at internal page 13. So, estimated work value is 4860. Annualized value would come to 972. 20% of annualized value 194. Working capital of the petitioner 195. Now, what MCL does is, estimated value is this. They add 18% GST to it. And they calculate the total estimated value as 5375, whereas the word used is estimated value, not total estimated value. And then the annualized value, they make it as 1147. But here the annualized value just above is 972 crores. Here they make it as 1147. And then 20% of this 1147, they calculate it, and working capital of the petitioner is 20%.
So it's a very small case, whether the GST should be included annualized value or the GST should be excluded as an annualized value.
Yes. Now, to just answer this, and their own understanding, they say in the counter affidavit relying upon AFCON and Monte Carlo and other judgments, and I accept the proposition, there cannot be any doubt about it. It is the employer who's the author of the tender document, and its understanding is one which has to be respected. The honorable courts will not interfere with it unless it is found to be perverse, mala fide, or the appreciation in understanding of the terms of the contract. Now, my lord, with this background alone, your lordships may come straight away to Annexure 7, page 166. When they award the contract to the respondent number 5, my lord, before that, my lord, just take one clause, is at page, my lord, the tender document, one more clause, which is very, very important, is page 57. My lord, once everybody competes and somebody is to be awarded the contract, then he has to give a performance bank guarantee, which is at page 57, my lord, may kindly see. Clause, my lord, security deposit, page 57. And we are concerned with, my lord, clause 4.2.
Yes, 5% of the annualized value of the contract.
Yes, my lord, that's 5% of the annualized value of the contract. Now, my lord, the contract which is awarded to the private respondent, number 4, is at page 166, my lord, Annexure 7. Letter of acceptance. This is under challenge, my lord. Initially, it was not given, and then by way of amendment, I challenged
167.
Yes, 166. It starts, my lord. Annexure 7, page 166. Letter of acceptance, my lord.
Yes.
Now, my lord, straight away, may I invite your lordships to page 171, when they are asking him to give the performance bank guarantee.
Yes.
Now, my lord, kindly see the amounts which are quoted at page 171. My lord, total estimated amount excluding GST. Have your lordship got it?
Where?
Well, page 171, the column which is there, the bid amount by the successful bidder.
Yes.
Total estimated amount excluding GST. It is in bold, my lord, at page 171. In the column, my lord, 7th, 8th column, 9th column.
Table.
Yes. table. Well, it says total estimated amount excluding GST is 4860. Have you watched it, my lord?
Correct.
Then, my lord, GST is 18%. Total estimated amount is 5735. So, my lord, without GST is 4860. This is 5735. Now, my lord, he has been given the contract. Total quoted value including GST comes to rupees so and so. The annualized value of the contract amount excluding GST is rupees 768 crores with the period of contract of 1875. Therefore, performance security, that is 5% of annualized value of the contract amount, that is 768 crores, is 38 crores, and so, you are advised to deposit performance security of 38 crore. So when you are disqualifying me by including GST, by saying that annualized value will be 5% of including GST. And when you award the contract to the private respondent number 4, you award the contract to him and you say the annualized value is without GST and 5% of that is 38 crores, you pay that. Well, I need not show anything beyond this at page 171, which is there.
Yes.
Now, my lord, this is one aspect. Just to buttress it further, my lord. In fact, my lord, I have annexed in my rejoinder affidavit at least, my lord, 3 tender documents. If your lordship may permit me to only show one. Regularly, MCL has been practicing this, that the annualized value of contract has been determined on the basis of the net value, not the gross value, that is without GST. And my lord, one such illustration is in my rejoinder affidavit, which I have filed to the counter affidavit of respondent number 4.
Who is appearing for MCL?
Yes. And my lord, one more thing, I am the L1 bidder. My quoted price is...
You are assailing this particular aspect on 2 grounds.
Yes.
Practically 1 ground.
Yes.
You are saying that you have been disqualified having not shown the requisite or the adequate amount of money which is required under the tender conditions.
Yes, my lord. Working capital.
Because the estimated value was inclusive of the GST.
Yes.
Secondly, you say, apropos to this, you say that if they take this particular aspect as the condition precedent, then awarding the contract to another contractor indicates that they have excluded that GST to have the analyzed, the value to be arrived at, and inviting him to give a 5% bank guarantee for that. So this double standard, this is discriminatory in nature. They have to be uniform in all the stands.
Yes, my lord. And to further buttress, if your lordship, I am not show the document. I have annexed in my rejoinder affidavit.
No, you say as an exemplar in the last previous, every time they have excluded the GST, they have not included the GST. Yes. I understand.
Yes.
This is what you wanted to say.
And my lord, if they would have not done so, if they would have not disqualified me,
now,
I would have been the L1 bidder. Yes.
Answer.
Lordship will file estimated bid value at Annexure 3, page 143. It's written estimated bid value.
What?
Estimated bid value. The Lordship sees Annexure 3, page 142.
142?
That's the bid document.
Yes, sir.
Now, Lordship sees page 142.
Whose bid document?
Malaks?
Is you have uploaded?
This is GEM GE Marketplace.
That's understood, yes, sir. You have uploaded. That's a portal where you uploaded. Yes. Tell us.
Page 143 may be seen.
Yes, 143.
Estimated bid value.
Correct.
5,735 crore.
True.
On this 5,735 crore,
correct,
the assessment of working capital is to be
correct. Then how can you get a performance guarantee of 5%?
While giving the performance guarantee, it is stated in the tender. While doing the performance guarantee, the GST will not be included. But for working capital,
where you have indicated from those clauses that it will not be included.
Yes.
Sure, sir.
No.
That clause of 5%, sure.
No.
Yes, sir. Show me that clause, which is the clause of performance guarantee, page,
Page 57, my lord.
57.
yes. Show us.
Performance security.
Yes, sir.
The first part of the security request should be 5% of the annualized value of the contract, amount or contract, whichever is less, and should be submitted within 21 days of issue of the
Correct.
LOA.
So 5% of the annualized value,
Manoj?
5% of the annualized value has to be calculated on what basis?
Once the Lordship will find that at page
That means 5827.
5827.
Tell me that you have done the same way.
Manoj.
5827.
Manoj.
You have excluded GST and comes to 48 something.
No. At the time of when we have to calculate the annualized value, the estimated bid value includes the GST. So far as the performance security is concerned, Lordship, the notes.
Sir, please tell me. There is a formula which is given in the tender document
My lord.
to how to calculate the annualized value.
My lord.
So this formula talks about the estimated value.
Bid value.
You have shown me that the estimated value is 58 something.
My lord.
Correct? Then it should be divided by the number of the days for which, and then should be multiplied by 365 days. If the estimated value is 58, and then you have arrived at the conclusion that it should be 287 crores, which is according to you should be the working capital, or you should show that you have. He has shown 195 crores. Correct? So I would treat this annualized value at 287.
228.
Correct? Now, that means that GST has to be calculated and included in the annualized value. What you have done?
Lordship sees the 4.2 which was showing, Lordship.
How you have done? So,
in 4.2, Lordship, we see the note. Page 57.
Yes, sir. Show me.
4.2 note.
Contract.
Contract value for the purpose of deduction of performance security deposit would be exclusive of GST. So
Yes.
while determining the performance security, GST is not taken into consideration.
Yes.
So far as taking working capital, I've explained in my counter affidavit, shown how it is to be calculated.
No, that is what I wanted. You just show us. Yes. Yes. Anything more?
So, in order to calculate this, I have given the calculation in paragraph 6 of my counter affidavit. How we have calculated this annualized value.
Yes.
That is annualized value of the work shall be calculated of the estimated value divided by the period of completion days into 365. Paragraph 6 that is respectfully submitted by these opposite parties here that estimated bid value of the work in question is given in JM bid document annexure 3, page 140 of writ petition. The estimated bid value is rupees 5,735 crores or that is at page 140, which I am showing the Lordship. It is pertinent to mention that annualized value of the work, that is 5,735 divided by 125 into 365 comes to rupees 1,147 crores. Therefore, the working capital to be possessed by a bidder 3 months prior to the scheduled bid opening of the tender is to 20% of 1,147 crores, which is 229 crores. The petitioner as per NHFI submitted bid that it possesses working capital inclusive of excess lines to the credit and availability of other financial resources 195 crores. Hence, his bid for working capital has been rejected.
Yes.
to which my learned friend was showing, for performance security, we have indicated specifically that GST is not to be taken into account while calculating the performance security.
That's all?
May I answer it, Parvati?
That's all?
Uh,
Anything
And
more?
so far as the other things they were showing, that in earlier he has participated in tenders. Each and every time the working capital which he has shown is more than what he has given. That's why it has already been accepted. Working capital. If a lordship sees which we are showing in the rejoinder, earlier tenders, everywhere the estimated value is including GST. And the calculation made by him and the working capital submitted by him. If the lordship sees that, for example, page 312, your lordship.
Where is 320? No, you are referring a
The
rejoinder
rejoinder by the petitioner, the
to counter affidavit by the opposite party. No. Prakash Chandra Mohanty affirmed.
Malaks.
Yes. Show us which paragraph.
One says annexure. Annexure.
9.
Lordship may see annexure 9. There are two major page markings over here. One is internal page 37. Another is 290.
There is no annexure.
That's right. They have annexed it as annexure 9.
After December, sir.
Okay. No, these.
You can just a minute. Sir.
Hmm?
Just a minute. It isn't.
Yes. Annexure 9 is a photo state of another notice inviting tender.
Yes, that's what we are referring that in earlier tenders also. If your lordship sees, annexure, your lordship may come to page 37.
I'm looking at page 37,
Yes.
sir.
Lordship, estimated bid value, lordship.
Yes.
That is 1,700 some odd crores. Lordship got it?
The total cost of the work, including GST, or estimated cost of the work. What?
No, page 37, that is only written estimated bid value.
Where?
Annexure 9.
Annexure 9.
Yes, page 37.
24/4/2024.
Annexure 9.
Which one? What is that document?
That is
Show us.
NIT decade 24/4/2020.
Correct. We are on that.
Malaks.
Which one? There are 1, 2, 3, 4, 5, 6 columns.
Page 37. Thereafter, at page 37. It starts.
That.
No. 39. Sorry, 39. Page 39.
Yes.
Estimated bid value.
Yes.
1,755.
755.
Now, lordship may see their calculations. At page 56, I think, which it's overwritten, it must be running page 312.
What? Calculation is not given.
Require
56. Internal page.
That's a annexure 10, 55. 56 is a part of that. That's why I want a hard work.
Hearing question. After notice, resolution.
$55 it is then annexure 10.
Yes.
On page 56,
Yes.
the calculation made and the working capital given.
236.
Yes.
236 crore.
Yes, 236. Required they have calculated 99, excluding GST, but they are given at 236. So all along they have been giving the capital as 236, so it was never questioned. All along the bid value is given as per page 39, estimated bid value. If your lordship.
No, I got your point, sir. You need not have to.
No.
You wanted to say that so far as the notice inviting tender is concerned, the estimated value has already been given, which includes the GST.
No.
And when the formula to calculate the annualized value is concerned, talks about the estimated value divided by the number of the years for which the mining lease is granted, and then multiplied by 365, then it comes to a particular amount, and 20% of that amount must be shown to be available to the intending purchaser. In that event, since he did not show that, that's why he was discarded. Secondly, the performance guarantee, the note says that it should be calculated excluding GST, so that was done by them. So in both the cases, which he has taken a point, it is not maintainable. That's the only thing. I think this could have been argued in 30 seconds.
My lord, can I reply back immediately, my lord?
Yes.
Now, my lord, my friend showed your lordship annexure 3. My lord, annexure 3 is not their document. Kindly see annexure 2 first. This is their document which is uploaded by them, MCL. Mahanadi
Talking annexure 3, the GEM, the document is uploaded on the GEM.
GEM is a portal which is being...
Understand, nowadays everything has to be done
through GEM.
That's the portal where all the government organizations, undertakings, they have to just upload their documents.
Absolutely no dispute in that, my lord.
Well, they have uploaded it.
Yes, so now, my lord, let's come to, my lord, clause 4.2, which my friend has shown with the note in that.
Yes.
Just see that clause, my lord. That clause has two, just read that clause, my lord, and the answer would be there, my lord. The note would not apply. Why? My lord, just see the note.
Then what is the purpose of putting a note?
No, note, my lord, the note, there are two ways of calculating performance guarantee. If your lordship may see the clause itself, performance security should be, my lord, kindly take that, my lord. Performance security should be 5% of annualized value of contract.
True.
Part 1. Or contract amount, whichever is less. And my lord, annualized value of contract, my lord, and kindly see the note, contract value. So second is the contract value or the contract value. So when it comes to contract value, if it is lesser, my lord, here the annualized value is lesser. My lord, contract value is 5,000 crores. If your lordship may see annexure 7. That's the point which I am saying, my lord, to your lordships, and which conveniently, if your lordship may see annexure 7 for a moment, that letter which is there at page 171. My lord, the contract value is 5,735 crores. They are not asked to give the bank guarantee on 5,735 crores. Because it has to be excluded, GST has to be excluded, and annualized value is less, would be definitely less. So this clause 4.2 says, where the annualized value is lesser than the contract value, you give the bank guarantee of 5% of annual value. So there are no two double standards so far as annualized value is concerned. And annualized value is defined, my lord, in the contract itself, which I just read to your lordships.
Yes.
So, my lord, they can't say that annualized value, they have two definitions.
Yes.
So this is what, my lord, the exclusion which they are saying in the note.
Oh, that's all. You are in reply.
Yes, on a reply, my lord. This is the annualized value. And my lord, of course, the judgment, your lordships are completely aware of all the judgments. I have given a list of judgments, my lord. Only one judgment, my lord, recent judgment of Bansidhar construction. If your lordships may see that, because I was hearing, my lord, the placement which was there to your lordships of NG projects, then Jai Bholenath, which was a subsequent order in which NG projects itself, the same honorable judges had said it has been
is wrongly misconstrued or misapplied.
Now, my lord, a recent judgment of 2024 Bansidhar construction arising from, my lord, a BCCL matter from Jharkhand, my lord, from where I am appearing. My lord, may kindly see, my lord, para 37 of this at page 60.
Para
37, my lord. May I read it, my lord? The submission made by learned counsel for the respondent that the project in question being infrastructure project and also one of the mega projects, this court may not interfere, more particularly in view of the fact that the agreements have already been entered into between respondent BCCL and special purpose vehicle of respondent number 8 cannot be accepted. When we have found that the impugned decisions of respondent BCCL was grossly arbitrary, illegal, discriminatory and violative of Article 14 as held earlier, the government body instrumentalities are expected to act in absolute manner, particularly in award of contracts for mega projects.
That's a contrary decision.
Yes, a direct contrary decision, and it has been set aside.
NG, direct contrary decision to NG.
Yes, and it has been set aside, my lord, and the retender was directed to be done. In this case, retender was directed to be done. Same, my lord, a person was disqualified. It's a 2 judges bench only, my lord. This one also at page 42.
That is the problem.
But my lord, the NG project, that particular observation and paragraph. In fact, my lord, I should say, my lord, NG projects in the High Court, I was appearing before the single bench and the division bench, and that judgment was overturned. In fact, my lord, if your lordship would seek a clarity,
but this NG was not cited in the Bansidhar.
Yes, Bansidhar was not, NG project was not cited in Bansidhar. Nowadays, with due respect, my lord, NG projects is not being cited anywhere, my lord, across the country.
Yes,
because of Jai Bholenath.
Let us consider 2 cases are of the same nature.
Yes. Now, my lord, just if your lordship permit me by way of rejoinder, your lordship have been kind enough. My lord, what my learned friend showed to your lordship in my rejoinder, annexure 9, page 37.
What?
Another NIT, my lord. Analyze value thing which friend showed.
No, he has said that in all the cases where you participated and you are taking advantage of it, everywhere your working capital always exceeds. Even if the annualized value is considered without GST, or if it is to be considered with the GST, your working capital was always more than that. So they never took a very hyper-technical view in this regard. And they accepted your position.
So that's what they are saying. But if your lordship may just see, when I submit my bid, I have to give what is an annualized value. That, my lord, they have accepted all along.
But suppose if there is a mistake which is committed earlier, does it create a vested right into a person that he should continue committing a mistake?
No, my lord, it should not. My lord, negative equality.
So in that it can't be. Let us go and examine whether these terms and conditions which are there have to be strictly followed. Have they strictly followed or not followed?
Yes, my lord, page 57, if your lordship may see with me only once more, my lord, that clause 4.2. That's
true.
That's the whole crux. My lord, if your lordship may see, performance security should be 5% of annualized value of contract amount or contract amount, whichever is less, and should be given within 21 days. And the note is with respect to contract amount. Contract value for the purpose of deduction of performance security should be exclusive of GST, not annualized value. And annualized value is, my lord, defined at page 24, which I had shown to your lordship, my lord, at page 28. Where annualized value is clearly defined. And my lord, at
Yes,
page
anything
one,
more? Anything more, sir?
and my lord, just one more thing. Page one, my lord, I know, my lord, I'm taking a little benefit of your lordship's indulgence. Page 171, my lord, if your lordship may see, my lord, the calculation which they have made of the bank guarantee is on annualized value. They mention it is 5% of annualized value because it is less than the contract value. But at page 171, if your lordships may see, the annualized value of the contract amount excluding GST is so and so with the contract of so and so. Therefore, the performance
Where is a calculation of a contract value?
Yes, that contract value calculation, my lord, is given here at the top. My lord, total estimated amount 4860. GST,
Where?
my lord, the figure which is there, my lord, the table above.
Where? Which page?
Page 171, my lord. Page 171.
Yes. There's no page 171. I do not know from where this 171 came. Your petition,
It's in the amended writ, my lord.
your petition ends at 160.
Well, that was in the amended writ, my lord. We have filed an amended writ also.
Where is the amended writ? Where is the amended? There's nothing. That is the whole big issues here. They are taking me to 57 to 171, from 171 to 15, and then going to 250. That's the whole irony. In a PDF form on a virtual mode, it's very difficult. And we do not find that he has filed a hard copy.
Actually, I am also relying on the IA also. Because of the
Where is the hard copy? No file, nothing. Is not there on the record. It ends at page 165 or so. Why? What is the purpose of then? What is Order 6 Rule 18 of the court? After the amendment is allowed under Order 6 Rule 17? What is the duty of is a duty of the department or a duty of the party? Tell me.
My lord, it is the duty of the party. And my lord, your lordships, while permitting us, had directed us to file a consolidated amended writ petition, my lord.
Has to be, once the amendment is allowed, the amended copy has to be filed.
Yes, we had, my lord, it was filed, my lord.
It is not there in the record.
But in the online records, my lord, it's showing for your lordships, my lord.
What is the page number?
Page number 171, my lord. I read it also, your lordship, that see in it, Annexure 7. If your lordship may see in your PDF format, my lord. Annexure 7.
Copy. Consolidated copy carries up to 167.
That is what I'm saying. 165, 167.
Resignation me. Register
Kajal, please guide.
No, I am there at 171. It does not talk about the contract value.
Yes, your lordships may just see the contract value. My lord, if your lordships may see from the heading, the columns which are there, total estimated amount, then GST, then total estimated amount so and so, quoted value by the L1 bidder.
Correct.
That is 79.03% of the estimated value, including GST, is 4532. This is the contract value, my lord.
How do I know that this is what the contract value is?
My lord, kindly see, my lord, at the so quoted value by the L1 bidder, that is 79.03 of the estimated value, excluding GST. Total cost to the company is 3841. The quoted value, including, comes to rupees so and so, 2 crore so and so. Annualized value of the contract amount is so and so with the period. Therefore, performance security is to be given. You are advised to deposit performance security as per clause 4 of the GTC the time for completion, next page, commencement of the work would be so and so. The contract value which is there is the calculation which is given at 3841 is the amount in which it has been given to him minus GST.
Yes, that's all. Thank you.
Thank you, Lord.
Yes. Concluded. Oh, when we have directed that matter to be listed. Earlier one? For orders, sir. Put it on that day. And give this and that both. Yes.
Much obliged, my lord. Much obliged for your patient hearing.
Item 9.
That the district education officer Kemuja invited tender from the manpower service provider for providing 27 numbers of class 4 staffs as peons, science laboratory attendant and night watchman cum sweeper for 9 Odisha Adarsh Vidya of Kemuja district. But pursuant to the tender con notice, the petitioner along with others, they participated, my lord, and after technical bid, financial bid was opened and 3 contenders they equally quoted price bid. Thereafter, lottery was conducted, my lord, and in the lottery, the petitioner came out successful. The lordship may kindly see, this fact has also been admitted by the opposite parties in the counter affidavit. Page 2 of the counter affidavit, running page 34, my lord, paragraph 3. But as 3 contenders quoted the same price and 2 tenderers quoted the price less than the minimum, the committee unanimously resolved to discard the proposal submitted by the 2 tenderers quoting price less than the minimum and to go for lottery among the 3 tenderers quoting the same price. Accordingly, lottery was held in the presence of the committee members and the tenderers, their representatives, as a result of Royal Security Services, Laksheshwar Agency Bhubaneswar and Anil Security Services have been finalized as L1, L2 and L3 bidders respectively, and it is decided to issue work order in favor of L1, that is Royal Security Service, who is the petitioner before your lordship. At that point of time, what happened, my lord? The Laksheshwar Agency filed a complaint that way back in year 2017, I was a blacklisted agency. Therefore, work order should not be issued. That Laksheshwar Agency also, my lord, relying on a letter of the collector, filed an intervention petition in this writ application, and your lordships are pleased to reject that by order dated 29/7/2025. With great respect, my lord, on the date of tender, there is no blacklisting order against me, and work order should have been issued in my favor. The Laksheshwar Agency, my lord, failed to file a single scrap of paper in favor of his contention, and I have not been issued the work order, my lord.
So you were disqualified at the technical stage.
No, my lord, I was all, my lord, we all qualified at the technical stage, and at the financial bid stage, we quoted same price, 3 tenderers.
So lottery has to be done.
Lottery was done, my lord.
But you were excluded.
I became successful. I was the L1.
Achha, you were L1. But
L1.
later on, you have not.
L2 made a complaint that way back in 2017, regarding some issues, I was blacklisted. My lord,
But there was no document which was forthcoming.
no, he filed not a single document, my lord. Thereafter, he filed an intervention petition in this writ application.
No, that I know. I have rejected it.
My
Not
lord, my lord. On the
Rather, we
date of
reject-
tender in the year 2024, my lord, December, there was no blacklisting order against me.
subsisting.
Subsisting.
Well, I will only place the facts, Miller. Thereafter, I will leave everything to the right, Miller. 3 dates are important, Miller. The tender was opened on tender was quoted on 30th November 2020.
Just a minute. Yes. What is the tender date?
30th November 2024.
Yes.
It was quoted. The tender was opened on 2nd January 2025.
2nd January.
2025.
Yes. Yes.
No, Millard.
It was on 26.
It was 26/12, Millard, and financial bid was 22nd.
What is this? Tell me the correct date.
26/12, 2024.
It was opened on when?
26/12.
26/12.
Yes,
12.
2020.
Yes.
Director Millard, lottery was conducted on 2/1/2025.
2/1/2025.
And on the same day, Millard, the L2 bidder Lokeshwar, he submitted an allegation before the competent authority.
Whatever. Then has he shown any document?
No, Millard, they did it. But Millard,
Did you make any inquiry?
You have para 5 of the counter affidavit. Very nebulous.
paraphrase.
Counter affidavit by opposite part number 4. You have filed.
Yes, Millard.
You have filed. Para 5.
Yes.
Instruction is awaited.
2016.
Yes.
You are referring in 2025.
Yes, sir. I'm
Then your counter is incorrect.
I'm
Incomplete.
Yes, sir. I'm coming to that.
Then what are
Director,
the?
Millard, we obtained instruction from.
You have no concrete evidence. That's why you have not published anything.
At that time, we didn't have that document. Millard.
And then
Subsequently, Millard, we got the document from the collector Balangi that blacklisting order was passed in the year 2017. Millard.
correct for
That the time period is not noted in that
so
document, Millard. And
is it perennial in nature or
as per law, it may be up to 3 years.
maximum?
Max 3 years.
So that expired in 2020 and this tender is floated in 2024. So there is no subsisting blacklisting order.
Another aspect they have written in the blacklisting order that Millard. The DSW, District Social Welfare Officer, he lost a FIR against this firm in Balangi. That is in 2017. And Millard, at page 14 and 15 of the brief, Millard, that
Any cognizance was taken?
Millard, as per my instruction, no cognizance is
Then-
taken.
Somebody with some kind of a motive does it, then what will happen?
That is
Disqualification.
All that you are asking against your counter. That is
Yes,
not there in the counter.
only submitting the facts, Millard. That is related.
Where is the fact?
Nothing is brought.
Millard, on
If it is not in the counter, what is the fact?
Millard, so far
Are you
as
arguing?
two documents are concerned, I will file an additional affidavit because I got all this one today. And the
Okay.
FIR is also I got today.
Nothing.
This is the actual aspect of this case.
Nothing.
Simply affair is lost.
Simply.
No, and then where is the charge?
Great testimony, Millard. Till date, I have not received a single summon from any court of law. And the services of the schools are also at jeopardy, Millard, because 8 OAV schools, the employees have not been deployed because of this. A generalized omnibus allegation, Millard, without a scrap of paper to concrete evidence.
So they have not published till date
Till date, Millard, no work order has been issued.
to anybody.
No.
And they have only stated in the counter affidavit that it is decided to issue work order in favor of the L1, that is the Royal Security Service
You
petitioner.
The petitioner.
so it is a classical example
I counter affidavit by that to tomorrow.
Which one?
Well, the item 10.
Yes.
I am for the petitioner.
No, I will take up all the matter. Don't worry.
Okay.
Whether it is 7 or 8. Yes.
Well, here, the state was to file an counter.
So he is filing it.
Yes, so if you need a little more time.
On the prayer,
Item number 11.
yes.
For the opposite one or 9, I am on VC, my lord.
What is this, sir?
So far, the stolen copy in favor of copy number 9 and 10 to be passed, my lord. Because we kindly see to the annexure 1 to this petition address 14, the permission which will be granted in favor of copy number 9 and 10, my lord, which clearly shows, my lord, that the page 16, my lord, there is a condition that the permit holder may, when I got it,
Page?
page 16, my lord.
Yes. Permit holder?
The permit at the only permit shall not carry on the surrounding operation within a distance of 50 meters from any public use.
Which one?
Temples, and so on, so all these things.
Clause 1, 2, 3, 4, 5, 6, 7, 8, 9. Which clause you are reading?
Clause, that is clause number I.
I, there is no I. Page 16.
Yes, sir.
This is 20th January 2025.
So, 2, annexure 1 is 2/11/24.
Oh, that is page 14.
14, my lord.
Yes.
That's so far the only page in 16, my lord. Clause I.
Running phase 16 is the another 20th January 2025.
15, I. Clause I.
15.
That's I. The permit holder.
As soon as what?
The permit holder. Page 15 is.
Yes, yes, GHI.
Permit holder.
Carry on within the distance of 50 meters.
Sorry, permit shall not carry
Yes.
surrounding operation within
So what? Yes, they will not. Then
then there might kindly see the 21/2025 letter of the revenue inspector in which he has categorically said, my lord, in serial number 5, man.
Yes.
Distance from dwelling.
Page.
Page number 17. Got it? That is the 21/2025. Make the
page is not telling actually. Yes, anyhow.
5, my lord.
Yes, 5.
From dwelling house, public habitation to the proposed site within 180 to 300 meters of Yoga Basti and Telli Basti of Pandapada, Mouja under Chancellor Council. Clause 6, distance of primary school to high school and college of Pandapada, Mouja to the proposed site is about 250 meters, my lord. But this being the position, my lord, then thereafter I kindly see. Okay. So for the guideline of for environmental sound operations for stone carrier, and it's not 5 meters. At page 24 meters. Clause number 11 and 12. May I press for
Page.
yes, no blasting shall be permitted, but if a public road, railway line, or any human settlement is located within 500 meters from
Which one is?
site,
11 and
where residences for
Yeah,
labor
that is-
and temporary structures should be constructed at the east.
Sir, what do you want to do? Come to the main point.
Yes, I'm going, madam. So far as the inhabitants are within that area, madam, how the blasting, if they are saying this is the condition for the blasting, and within that area, all the near about 100 to 200 residential persons are there, madam. So to that extent, my expert to submission, the persons are going.
Sir, it does not talk about. It simply says that it should be away from the temples, there should be away from the public building, but not the private building. It does not talk about that.
Yes.
It says the public building, the reservoirs and all these public utility services, it should be away from there.
Yes.
So, and the blasting must be done it should be away from a public road, railway line, or UN settlement, at least within 500 meters
Yes.
of the quarry site. So they are beyond 500 meters of the quarry site. And they say that for the residence of the laborers, it should also be at least 500 meters away from the blasting site. So that's the only thing.
Yes, ma'am. That is so far as page 29, the representation made to the collector, clarifying to that extent, my lord, that is not beyond the 500 meters.
Now there is a preliminary objection taken by them. What is that preliminary objection?
Preliminary objection taken by OP9, but in respect of the same stone query, another PIL was filed earlier that your lordship has already
Dismissed. So
Yes,
with cost or without cost?
without cost.
Without cost.
That is
This
WPC
time with the cost.
May I have a copy of that order, my lord?
Oh, this is the majority have said that no problem, only he has a problem. Same gentleman, Pradeep Kumar.
No, not same.
Sorry,
Another
Pradeep
batch
Kunwar.
of village. Yeah.
Huh?
Another batch of persons they have come. Filed back.
After this order?
Yes.
No, before this order.
After filing of the present writ petition, the writ petition is filed, which is dismissed by lordship.
No.
That is 16126 of 2025.
That this my representation is 701 of 25, but this representation is 16156 of 2025. That is letter also. I have to go through that order. It is passed by lordship. I have no knowledge about this.
Yes, what? The collector has said that their majority, they said that we are not affected.
We have to go through that.
What go through? This is a
Same village.
same village,
Same.
Salabeda. So,
No, I have no knowledge about this because.
no knowledge.
No, because.
So innocent. You live in a village or outside the village? Tell us.
Later on, this has been filed.
Sir, tell me, you live in a village or outside the village?
Village of Somalia.
Correct. So villagers are so integrated. Their families are so integrated amongst the village. If one villager goes to the court, everybody knows that he has gone to the court. And you don't know. Some of them have approached the court and their writ petition were dismissed.
So I am saying I have to inquire about the matter. What is the position of this?
What is the position? Is it believable story?
I am not disputing that, but I have to go through that. What is the position? I have to take instruction in that regard.
We will grant you, but after that, if we find that your client was all along aware and is only just to put a spanner to the entire issue, we will impose a hefty cost on them. If they want to play a trick to the court and come without any clean hands, we will not spare. The majority peoples, they wanted. Now you are only one or two or a handful of persons who are registering and then come. All the majority villagers have no objections. They have not come forward. Only you have a problem. Let's put it day after tomorrow. First matter and keep it. Yes, why everybody was restless? We can't avoid it.
I'll tell you what's Lordship are calling all the matters.
Oh, I have to then.
No. I'll tell you Lordship why. I have item 45. And there, what is happening is So the time even I'm able to get a certified copy and give it to them, they are stopping my mind. And in the process, your lordships have now seen these MDPA demands.
Tenth.
On 10th, that's the first matter, your lordship.
So then